that way. The loan was for $28,000. It's really sad that all of this was lost over $28,000. The monthly payments was close to like $300 a month, but I was on a fixed income, and it just got to be too much. Wells Fargo was the mortgage servicer, and that's who serviced my loan and who I got the loan through. I really, at that particular time, didn't know all the ins and outs of a mortgage loan. I just took it by faith that I was going to be okay. Settlement was really fast. You just don't know. You know, you're trusting your mortgage broker, you're trusting the settlement people, you're trusting the bank, and what else can you do? You really don't have a clue. You're just happy to have someone say, yes, we will finance you. Yes, you are approved. Yes, you can go to settlement.
That's an excerpt of American Casino, the story of the people who are foreclosed on. Finally, Elizabeth, you talk about the joke in the office being that pushing these subprime loans as being riding the stagecoach to hell. Well, now you're off that stagecoach and you're doing foreclosure defense?
Correct. I'm working with several attorneys in the state of Maryland. And most of these people that we're seeing come in were put into predatory loans, and these loans were sold as mortgage-backed securities. Most people have no idea who actually owns their loan. Wells Fargo could service it, Chase could service it, Bank of America could service the loan, and people tend to think that that's who owns their loan. So they get the foreclosure filing, and what we do is ask them to produce the note to prove that they actually own the loan, because there's most cases there is no chain of custody of the note. And in Maryland, there's no requirement to produce the original note. So we're trying to put up that defense. We're trying to get the word out there. Very few people realize they could possibly have a defense. And there's some defenses out there that are just rather technical. The plaintiff that's filing the foreclosure doesn't follow the law. They'll put one entity down on the notice of intent to foreclose as a secured party. Then when they file the order to docket, which is the instrument that's filed in the circuit court, it'll list a totally different company. And what happens is, unless the homeowner puts up some sort of defense, these are all rubber stamped. Maryland is a non-judicial state. It just goes through the system. So these plaintiffs' attorneys can basically put whatever they want in these documents, and the judge isn't going to look at it unless the homeowner says, wait a minute, let's put up some sort of defense. And I'm also finding in helping people doing these defenses, and actually through loan modifications, part of HAMP is that you are to stop all foreclosure proceedings, including, of course, the sale of the house, if a homeowner has applied for HAMP. They don't even have to be approved for HAMP, just the application for HAMP. And that's not known out there. So there's a lot of benefits, obviously, going with the HAMP program. But the lenders will still move forward with a foreclosure, even if you've applied under HAMP, which is prohibited.
Well, we were going to leave it there. Elizabeth Jacobson, thank you very much for joining us and for coming out as being a top loan officer, subprime loan officer at Wells Fargo. In June of this year, she submitted an affidavit in support of a federal lawsuit in the city of Baltimore against Wells Fargo. She now works in foreclosure defense. As we wrap now, Juan, with our last segment. Yes.